spacious skies, for amber waves of grain, for purple mountains, majesty.
Gonna wait for a few more people to pop in and we'll get started. Okay, welcome everybody to the Alturas Institute's Constitutional Conversations. My name is Taylor Nadald and I will be hosting today. That song that you just heard was arranged by Steve Eaton and features the singing talents of Idaho State Senator Cherie Buckner Webb and 8-year-old Charlotte Lavelle. So we're super grateful that we could use that musical arrangement for our program today. Before we get started, just a few housekeeping items. As always, we encourage you to donate to the Alturas Institute. We are a nonprofit, nonpartisan organization that promotes civic education, civil discussion, and gender equality. So we really appreciate your donations. They help us to be able to put on events like this and invite really cool guest speakers to come visit Idaho. So thank you for your donations. As always, we have a donate button on this video. You can also go to our website. It is alturasinstitute.com. And we are now on Venmo. So you can find us at the Alturas Institute. That's all one word. If you have the Venmo app, it makes it super easy for you to donate to us. And then we always accept checks to our physical location at 428 Park Avenue in Idaho Falls, Idaho. That's 83402. So without further ado, I'm going to introduce our speaker today. It's Dr. David Adler. He is a scholar of the Constitution and president of the Alturas Institute. So we're really excited to hear from him again today. It was requested that we have a Q&A session, so we're really excited to do that. We're going to have the Q&A session at the end of this lecture, so if any questions come to mind throughout this program, just submit them into the comment section, and we will do our best to get to those. So I think that's everything, so I'm now going to introduce the Alturas Institute President, Dr. David Adler.
Thank you, Taylor, and good evening, everybody. Thanks for joining us. Tonight, we stand at a historic crossroads. We have just lost a towering giant, a woman who for 27 years championed on the Supreme Court the cause of gender equality, the author of numerous opinions that paved the way for the application of the 14th Amendment Equal Protection Clause to protect women against discrimination. Last Friday night, we lost Justice Ruth Bader Ginsburg after a very long struggle to pancreatic cancer. Her efforts were well documented on no less than 5 occasions. She was able to survive the dreaded disease and kept going, kept working. She didn't take days off. As many Americans know, the notorious RBG was notorious for her work ethic and her stamina. And she was always leading the way, writing more opinions for the Supreme Court than everyone save for one justice, despite her battle with cancer. When Justice Ginsburg succumbed to cancer on Friday night, the nation wept. Tens of millions of Americans mourned the loss of this towering legal giant whose work in the cause of gender equality had begun in the late 1950s and the early 1960s as her career as a law professor at Rutgers University, provided her with the opportunity to begin to deliver lectures in the classroom, to devote seminars to her theories about women's equality, applying the 14th Amendment Equal Protection Clause to argue that discrimination against women cannot be tolerated, that in fact the 14th Amendment does not tolerate gender discrimination. Over the years, she would begin to write more articles, deliver more lectures, make more appearances at Bar Association meetings, and her students at Rutgers would carry the torch out across America as they began to enter the legal profession. It was the case Reed versus Reed in 1971, where she wrote her very first legal brief to the United States Supreme Court. This was a case arising out of Idaho, which involved a 100-year-old statute that provided that in the case of a man and a woman, both asserting the need or the interest or the right to serve as the executor of the estate, that the preference should be given to a man because the territorial legislature of Idaho in 1864 believed that in fact men have a better head for business than women. When Justice Ginsburg wrote this brief on behalf of the ACLU, working in tandem with a dedicated, skilled Boise attorney, Alan Durr, she was able to provide a very formidable brief, one which drew upon the landmark achievements of Thurgood Marshall, who had argued on behalf of African Americans to the Supreme Court, asserting that discrimination against African Americans violated the Equal Protection Clause of the 14th Amendment. And when Durr and Ginsburg were able to prevail in the landmark case of Reed versus Reed, where Chief Justice Burger on November 22nd, 1971, authored a unanimous opinion for the court holding that discrimination based on sex violated the Equal Protection Clause, there was great applause, not only in Idaho, but across the nation, because this was a tremendous victory for the cause of gender equality. That launched Justice Ginsburg, or then law professor Ruth Bader Ginsburg, into the upper echelon of the legal world. And soon she would be arguing cases before the Supreme Court. And in 1973, she argued her first case and she prevailed. For the next several years, she was a supremely successful advocate before the court. And it wasn't long before then President Jimmy Carter named her to the DC Court of Appeals, where she served for 16 years before President Bill Clinton appointed her to the Supreme Court in 1993. And she became the leader of the progressive wing of the court and became its most senior voice after the retirement of Justice John Paul Stevens. And she was able to not only write several majority opinions, but her dissenting opinions were powerful, insightful, and held the majority to account when the majority was able to prevail in numerous 5-4 decisions. A nation on Friday night, and to this very day, continues to mourn the loss of Justice Ginsburg. And now we're at a crossroads, because President Donald Trump and Senate Leader Mitch McConnell have decided to move very quickly, indeed immediately, to fill the seat left behind by Justice Ginsburg. This is, for many Americans, many scholars, and others, deeply disturbing that the court would move so quickly to fill this seat. Let's consider tonight the importance of the appointment power, what stands behind Article 2, Section 2 of the Constitution, which grants to the President the authority to nominate men and women to the Supreme Court of the United States, and contemplate the very important role of the United States Senate in playing in carrying out its power to grant advice and consent. This is a very, very important power. And then we want to move on a little bit to talk about the current arguments and its implications for the future of the Supreme Court, for this election, and indeed for the future of American constitutional democracy. In 1787, when the framers of the Constitution were drafting that magisterial document, the issue arose: how do we provide for an appointment power? Who should make appointments to superior offices? This was an important issue, one that had caused great consternation for the founders, because during the colonial period, Americans had seen how King George III, whom they regarded as a tyrant, had essentially abused the appointment power to name to important offices and even lesser offices his aides and friends and cronies and political supporters. Thus, in the view of many Englishmen, and certainly in the view of many colonists, he was perverting the all-important power of appointment to high office. After all, English legal scholars had written about the importance of the appointment power. Sir William Blackstone, the terrific author of a 3-volume commentary called Commentaries on the Law of England, had written in the first of these 3 volumes published in the 1760s that the aim of the appointment power should be to place into high office those most meritorious, talented, and capable people who could serve as administrators of those offices. But those words fell flat. They stood on parchment under the monarchy of King George III, who decided that he would advance his own powers, his own interests, sometimes personal, sometimes political, sometimes pecuniary, in naming people to these offices. The colonists across the Atlantic witnessed all of this. They felt some of the sting of the abuse of power firsthand. And so that founding generation was keenly aware about the propensity for the appointment power to abuse that power. And thus, when the framers in 1787 in Philadelphia began to structure the Constitution and they turned their attention to the appointment power, they were all in agreement that the appointment power should not be a unilateral power exercised by the president, but that it must be checked. It must be balanced by the United States Senate. And here you can see in the notes kept by James Madison throughout that long, hot summer that the framers were committed to ensuring that the Senate would be viewed as a partner with the president. As I say, this would not be viewed as a unilateral presidential power, but indeed a jointly held power, shared by both the president and the Senate. And as you look at the Constitution, by the way, one point of distinction in this document is that the most important powers are always powers that are shared by one or more, by 2 branches. And the appointment power was no different. If you look at Article 2, Section 2 of the Constitution, you'll see the familiar language. The president shall nominate, and with the advice and consent of the Senate, appoint ambassadors, other officers, and members of the Supreme Court. Now, let's consider why it's very, very important for the United States Senate to exercise its power with due diligence. After all, while it is certainly true that when the Senate grants its advice and consent, that is, confirms the nominees sent to the Senate by the president with respect to ambassadors or cabinet members or other superior officers, that in fact it is very important for the Senate to take care to carefully consider the qualifications, the merits, the views of those nominees sent to the Senate by the president. But those offices, cabinet posts, for example, will likely be held by a nominee only for a couple of years or perhaps 4 years. The difference between those important offices and posts is very, very clear. Under the Constitution in Article 3, which is known as the Judiciary Article, the Constitution provides that members of the Supreme Court shall serve during good behavior, times of good behavior, which is to say they will remain on the bench so long as they do not commit an impeachable offense. And as we all know, over many decades, the appointment of a man or a woman to the Supreme Court essentially means that a person is serving on the Supreme Court until he or she decides to retire, creating a vacancy, or whose life is taken. And so the conception of a Supreme Court justice serving during good behavior has, as I say, for all intents, become a lifetime appointment. Therefore, it's critical for the Senate to exercise its reviewing power, its consenting power in a very critical way. And all the more important when reviewing the credentials and qualifications of those who would be named to the nation's highest court, where they will be in a position to interpret the Constitution, to interpret and apply statutes for many, many years to come, shaping public policy in a way that few men or women ever have a chance to do in American politics. When the framers, therefore, provided that the Senate would be given an equal share of this power, it was anticipated the Senate would not be a rubber stamp, as much as members of the Senate might, in fact, share the views of the president, or later to become a member, essentially a member of the president's political party, sharing a relatively conservative or liberal outlook with respect to the politics in our country, or hold similar views on social or cultural issues. It was always expected that the Senate would look very carefully and hold extremely probing hearings. Historically, these hearings have lasted on average for 70 to 75 days. Indeed, we have never in our history approved of a presidential nominee for the Supreme Court in the time period being pursued now by President Trump and Senate Leader Mitch McConnell. We are roughly 35 days out. This expectation by the president and by McConnell that the Senate could exercise due diligence in roughly a month or so is a little bit out of kilter. After all, consider that in the only other case where there was a comparable period of time, when in fact Chief Justice Roger Taney died in 1864, President Lincoln decided that 27 days removed from the election was simply too short a time to ask the Senate to do its constitutional duty, that it was not expected to be a mere rubber stamp for the president's nomination preferences, but in fact carefully exercising its own power and responsibility, bringing the senator's own judgment and wisdom to bear to determine whether someone was fit to serve on the Supreme Court. And so Lincoln did not, in fact, ask the Senate to move in 1864 in a 27-day period. Unlike President Lincoln, however, President Trump is determined to move full speed ahead. Here we are on a Wednesday night, and the president has announced that he will announce his nominee this coming Saturday, barely a week after the passing of Justice Ginsburg. Now, a number of senators have indicated that they believe that they can, in fact, exercise their constitutional responsibilities and thoroughly vet the qualifications and examine the relative merits of a prospective nominee. At this point, many expect that to be a jurist from the Seventh Circuit Court, and that is Amy Barrett, who has also served as a law professor at Notre Dame. But can we really expect this Senate to move so quickly? Let's examine this. The first thing we want to know, frankly, is that under Mitch McConnell, over the last 4 years, the Senate's skills in exercising its advice and consent power surely have rusted. Why do I say that? Consider that so many members of President Trump's cabinet have never been submitted to the Senate for advice and consent as required by the Constitution. So many of the people holding the key positions as department heads, which require Senate consent, have never been submitted to the Senate. We have, in short, a period of time in which for this current president outlasts the efforts of any other president to exercise a temporary appointment power. No president comes close. And in fact, if you look at the very number of hours of acting heads of departments under President Trump, the number of hours under this president more than triples the number of hours of Barack Obama's acting appointees over a period of 8 years. And Trump is just about finished his first term. What this really means then is that we look at the continued diminution of the role of the United States Senate in carrying out its power to grant advice and consent. If we once more remember that the framers thought that the appointment power was a jointly held power, and critically so that the president could not exercise power to move through the process, eliminating the process, in fact, so as to put aides and cronies and friends in office, people who would do his bidding, understanding that as acting heads, they might be removed by the president at any particular time. We see that the Senate's refusal to exercise its power of advice and consent in the way expected of the Constitution not only diminishes the importance of the Senate, but, ladies and gentlemen, it robs the American people of the expectation that cabinet members and high-ranking department heads will have been submitted to the United States Senate. So the Constitution, we should remember, was not written for the president, was not written for the Senate, it was written for the American people. And the American people have every right to expect that the terms of the Constitution, its provision, its textual allocation of power would in fact be vigorously promoted, and that the president and the Senate would be expected to live up to the terms outlined in the Constitution, and certainly in the case of the appointment power. That's not been happening. So as I suggest, when Senate Leader Mitch McConnell believes, and many of his Republican supporters in the Senate believe, that they can move swiftly to exercise the power to consider and likely approve President Trump's nominee, I'm wondering, how do they remove the rust from that power so quickly? The power that's been lying around barely used for 3 years. Ask yourselves this: how many of the tools in your tool shed are as efficient when they have not been used for 3 years or so? Or how many of your own personal skills are as sharp when you've not been exercising them for 3 years? So I doubt very much that the Republican leadership truly believes that the Senate can exercise due diligence, bringing wit and wisdom to bear to carefully vet the credentials and qualifications of Donald Trump's nomination. In addition to the rust factor, let's consider that in 35 short days, we are looking at the need for the Senate to move, to sprint so quickly, far more quickly in this case than this Senate under the control of Mitch McConnell has in 4 years. And if you recall that the average nomination hearing takes about 70 to 75 days, with the Senate moving at a good pace, allowing ample time for senators to meet one-on-one with the nominee, to ask pertinent questions during substantive hearings that will be undertaken by the Senate Judiciary Committee, we wonder what makes Mitch McConnell and Donald Trump and Republican members of the Senate believe that they can do in roughly half the time what has taken the Senate over the years to carry out its important advice and consent power and responsibilities. The answer, I think, ladies and gentlemen, lies in what Senate Judiciary Chair Senator Lindsey Graham of South Carolina said just the other day. And that is, he said, "We will quickly move to approve the president's nominee." Well, ladies and gentlemen, that was a premature comment. All cynicism aside, that was a premature comment because the Senate has yet to receive the formal nomination from President Trump. And what this really does is it provides a truly telling moment that there is not an expectation that members of Donald Trump's party in control of the Senate aim to provide a thorough vetting of the nominee of President Trump, not when we've already heard from the Judiciary Chairman himself that they will move quickly to approve. Well, what if there are some troublesome points that emerge during the confirmation hearings that may begin as soon as 2 weeks from this weekend? I think it just means once more that the Senate is dropping the ball, not carrying out the constitutional expectations and performing its duty and roles under the Constitution. Finally, there is the hypocrisy factor here that many Americans have worried about since President Trump announced that he would move immediately to replace Justice Ginsburg. Just a couple of hours after the public announcement of Justice Ginsburg's passing on September 18, Senate Majority Leader Mitch McConnell announced that the Senate will vote on President Trump's nominee. That's hypocritical, as you all know, because 4 years ago, in 2016, when the then sitting President Barack Obama nominated the Chief Judge of the D.C. Circuit Court of Appeals, Merrick Garland, to replace Justice Scalia, who had died suddenly, Senator McConnell said very quickly the Senate would not vote on President Obama's nomination because he thought they shouldn't hold a nomination hearing and should not vote on a nominee in a presidential election. And remember, ladies and gentlemen, that was 10 months before the election. And what became clear is that McConnell was going to abuse the power of the Senate to refuse to hold a hearing because he hoped that a vacancy on the Supreme Court might in fact be filled by his party's nominee, Donald Trump. So the hypocrisy of this rubs everybody wrong. And let's not forget that the hypocrisy is not owned by the Senate leader McConnell, but also owned by the Senate Judiciary Chair Lindsey Graham, who in 2018, told an audience at a forum sponsored by Atlantic Magazine that in fact, if he is the chair of the Senate Judiciary Committee in a presidential election year, that he would not hold a nomination hearing. That was 2 years ago, and in fact now he has backed away from that, retreated in the same hypocritical manner as the Senate Majority Leader has. And so it leaves us deeply concerned because apparently it means that the words of two very powerful U.S. senators, the Majority Leader and the Senate Judiciary Committee, don't matter, that principles addressed 2 years or so ago have now been vacated. They've been abandoned. And here we are, 35 days or so away from the election, and they're moving full speed ahead to fill the seat of Justice Ginsburg. So I harbor the same kinds of concerns that many Americans do, that many scholars harbor from coast to coast. I think that the fact is that the Senate's role will once again be diminished. It will not be living up to the expectations of Article 2 of the Constitution, and that we will be denied a full, fair, and thorough vetting of the nominee, which presumably will be announced by President Trump on Saturday. The fact of the matter is, ladies and gentlemen, over our 200-year history, the Senate has played a very critical role in checking and balancing the relative wisdom of a president in choosing people to serve on the high court. After all, historically speaking, roughly 1 out of every 5 presidential nominees has been defeated. An 80% success rate. That's about a B in your classroom, ladies and gentlemen. And it should be better than that, frankly. It's not higher because presidents have attempted on occasion to view the appointment power as their own power, as a unilateral power, forgetting that it's a jointly held power, and have essentially tried to leap beyond the Senate's constitutional role. The fact of the matter is that the Supreme Court now, by virtue of the partisan politics surrounding this appointment, has now become the center of a storm. In fact, the title of our program, Storm Center, is a phrase drawn from the words of the famous Supreme Court Justice Oliver Wendell Holmes, who explained that the Supreme Court often is often at the center of a storm. Other people have viewed the Supreme Court historically, when it's been ravaged by partisan division on the court, as 9 scorpions in a bottle. And here we are at this point in time in which the country is perhaps more deeply divided than at any point in our history since the Civil War. And it's a deeply concerning problem that the court now is at the center of this storm, because it's very important for Americans to perceive the Supreme Court as being an apolitical body, as rising above partisanship. But the more that U.S. senators twist and turn the seats available on the Supreme Court and state almost to a man that, in fact, they want now a deeply conservative jurist to serve on the court, tells American people, unfortunately, that this next nominee will carry views to the court, views that have been hardened over a period of years and reflect conservative views and values. And instead of carrying out a role of being an open-minded judge, one appraising the circumstances, looking at the past precedents and considering the arguments before the court, may essentially simply be imposing her own views, prejudices, and biases in the case. That surely represents a threat to the independence of the Supreme Court. After all, if the Supreme Court is not held in high esteem by the American people, not viewed by the American people as a nonpartisan court, sitting to simply serve as a mouthpiece for the meaning of the Constitution, as Alexander Hamilton explained in Federalist Number 78, then Americans will wonder, is the court any different than the legislature? And if the court is not different than a legislative body, then Americans will lose their respect. They won't lose their respect for the Supreme Court. They won't think as highly of the court. Well, they won't look to the court to resolve the important differences here in America. And so not only do we suffer at this point in time extreme partisan division among our body politic, extreme partisan division among the men and women serving in the House and the Senate, but now we run the risk that the United States Supreme Court reputation will undergo a really harsh re-examination, and more and more Americans will come to think of the court as a political body, one that can be manipulated through the appointment power. You'll recall it was only a year ago that President Donald Trump criticize Clinton judges and Bush judges and Obama judges. And that compelled the Chief Justice of the Supreme Court, John Roberts, who has made a career out of trying to promote the independence of the judiciary, to, in fact, rebuke President Trump and to say, we don't have Clinton judges and Bush judges or Obama judges. And presumably he would say, we don't have Trump judges. This is a very important time for Americans to understand that the critical independence of the Supreme Court is now threatened by this precipitous move to fill the seat of Justice Ginsburg. We so wish that, in fact, the views and wishes of Justice Ginsburg herself, who in one of her last statements to her granddaughter, an outstanding attorney in her own right, that her most fervent wish was that the next president would nominate a successor to her seat, would in fact be followed. Or, ladies and gentlemen, that in fact the polls indicate that 70% of the American people believe that the next president should nominate a successor to Justice Ginsburg's seat. We wish that this president and this Senate Majority Leader would show respect to Justice Ginsburg's last wish. We also wish that, in fact, this president and this Senate leader would follow the wishes of the United States Supreme Court and let the next president nominate the successor to the prestigious seat held by Justice Ginsburg. But apparently this isn't going to happen, that we are following the road of raw power politics, and the aim here is to pack this court full of conservatives whom Trump and McConnell hope will be able to push their agenda as jurists of something less than an independent order. Let's hope that doesn't come to pass. There still is time for the American people to contact their states, to contact their senators, and to ask them to hold their powder, to wait until the election is held, allowing the will of the people to prevail. Let us hope that the will of the people is not denied on this occasion. Thanks so much for joining us tonight. I now look forward to answering a number of your questions. Here at the Alturas Institute in this Constitutional Conversation series, we devote significant time to addressing the questions introduced by our audience. So I look forward to taking on those questions now. What do we have, Taylor?
Hey everybody, so thank you so much for your questions. Yeah, let's get that turned. Looks good. And we did have really quick a question in here about where people who are not able to watch this on Facebook can watch this video. So this will be recorded and put in our Facebook archives, and it will also be on our YouTube channel. And I can put that link up when this video is over so you guys can find that. But yeah, let's get to some questions from our viewers. So let's just start off. Colleen wants to know, could you talk a little bit more about your personal relationship with Justice Ginsburg?
Oh, thank you. I appreciate that question. My relationship with Justice Ginsburg stems from an interview on July 28, 2017, when we met in Sun Valley, where she was addressing the Utah Bar Association's annual convention. We met at 11:30 that morning, our appointed time for the interview, on the book that I'm writing about the landmark decision Reed versus Reed. That was the case that I mentioned earlier, which launched Justice Ginsburg's career into the stratosphere, and I very much wanted to hear from Justice Ginsburg about the entirety of her role in that case, and how she had approached the legal argument. She had, of course, written a profoundly powerful and insightful legal brief in that case, which was closely followed by the Idaho attorney Alan Durr in oral argument. And that interview turned out to be absolutely delightful. I'll tell you that while we had initially agreed on a 60-minute interview, we went well beyond that, well into 90 minutes. And she was very patient and exhibited tremendous stamina. Exhibited tremendous stamina because she had almost practiced an all-nighter that night. Indeed, on the evening of July 27th at about 8:30 p.m., I received a phone call from the federal marshal who was traveling with Justice Ginsburg, who was making her way from Washington, D.C. to Idaho. And the voice on the other end said that Justice Ginsburg wanted to speak to me. Well, I was delighted to have the opportunity to speak to Justice Ginsburg. I'd not ever spoken to her. We had corresponded through email, but I had yet to speak to her. And I was a little nervous because I feared that this phone call meant that our interview would be canceled. But instead, she took the phone and immediately asked, "Where are you?" I told her, being the honest citizen that I was in the face of a voice from a jurist on the high court, "Well, Madam Justice, I actually am in a car wash here in Idaho Falls, Idaho, but I plan to drive to Sun Valley tomorrow morning for our interview." She responded by saying she wasn't sure that she would make it to Idaho, and she wanted me to know. She wasn't sure because the plane was in Denver, and she wasn't sure the plane would make it to Idaho. So she wanted me to know, just in case. Well, we agreed that we would hope for the best, and I would, in any case, drive to Sun Valley to see her after she finished her remarks to the Utah Bar gathering. And so I arrived at 10 a.m. that day to hear her lecture and found my way into the limelight room of the Sun Valley Inn. And there, to my horror, the room was filled with 1,000 people, all waiting to hear the views of Justice Ginsburg. And there she was at the front of the room. She had made it. The federal marshal told me, despite the fact that her plane had not arrived until 3 a.m. in Boise. She only got a couple of hours of sleep. And then the federal marshal told me they had driven from Boise to Sun Valley, and she didn't use that time in the way that a lot of us might to catch a few extra winks. No, she sat up and did work. So this 84-year-old woman at that time then was operating on very little sleep, and we conducted our interview in a restaurant just off the limelight room. She was very gracious, very warm, and very supportive of my efforts to gather research for this book on Reed. Subsequently, that warmth and kindness continued to reemerge over the last couple of years, because every time I had a question, I would email her on, say, a Tuesday, and she would quickly respond the next day. And I thought that was pretty impressive because she was a pretty busy woman. So I'm very grateful for her warmth, her kindness, her support. She opened up her personal files on Reed versus Reed, and indeed her entire career at the Library of Congress, granting me permission to move through those. And so her own materials, in combination with her own remarks during the interview and the subsequent email exchanges, couldn't have been more insightful and helpful to me. So I feel a deep personal loss, of course, like tens of millions of Americans do. And this was a very sad day when her life ended, and she passed on September 18th, just one day after Constitution Day, I might add.
Yeah, that was very sad. It's so cool that you were able to have that relationship with her.
Yes, I feel very, very fortunate because she could offer insights into the case, into the arguments, offer her views on the behavior of the Supreme Court justices in Reed versus Reed, and talking about the legal hurdles that she faced in overcoming the historic discrimination against women. Remember, in Reed versus Reed in 1971, that was the first time in our country's history that the Supreme Court struck down a statute on grounds that it constituted gender discrimination in violation of the Equal Protection Clause. So she was a fixture. It launched her career, and to be able to discuss the case with her and to have her participation in my research and writing was so very near and dear to my heart.
Well, let's move on to another question from one of our viewers, Linda. She says, what is the role of citizens at this moment? How do we express our disapproval of this untimely appointment? Is there anything we can do? She says she's written to Risch and Crapo, but she's not confident in their support.
Well, I appreciate that question from Linda. She has done and is doing exactly what concerned citizens should do, reaching out to their U.S. senators, in this case, probably asking them to slow down, to delay the nomination until after the election. The other thing, of course, that she and others can do is to write letters to the editor, demanding that the Senate keep its powder dry and to wait until after the nomination. What our questioner is asking is a matter of deep-seated concern for many Americans, and this really raises the important question of our ability as citizens to hold the Senate accountable. Our system rests on accountability, and when U.S. senators are not acting diligently, essentially ignoring their profoundly important constitutional responsibilities, in this case under the advice and consent clause, the best thing we can do is to publicize their indifference to their constitutional responsibilities and campaign for their opponents, to remind everybody that the Constitution was not written for the Senate or for the president, but for the American people, and that American citizens then need to rally to the cause, either through letter writing, phone calls, and protests as well. After all, we do have a First Amendment right established by the Founding Fathers to protest governmental actions with which we disagree. So thanks to Linda for the question. Thanks for her good actions. And the reality is that if the American voters don't hold their senators accountable for their indifference to the Constitution, indeed for their violation of their constitutional responsibilities, then there will be no deterrent for our representatives, either in the Senate, in the House of Representatives, or in the presidency, to bother to adhere to the Constitution. So this is a grave moment in American history, and citizens, too, need to rise to the occasion.
Okay, David wants to know, what is your view of the Democrats packing the court if the Democrats were to take control of both the Congress and the White House?
That's a very important question. In light of the willingness of the Senate Republicans to essentially burn the Senate's role of advice and consent and to abuse its power in this second appointment, a nomination by President Trump, we can expect that Democrats might well be willing to resort to the exercise of the power of the Senate, indeed the full power of Congress, should they regain control of the United States and win the White House under Joe Biden, thus allowing the Democrats to move forward with additional judgeships. After all, the Constitution does not fix a number of justices. It simply allows the Congress to determine what the number of members of the Supreme Court should be. And historically, our number has ranged from originally 6 to 7 to a height of 10 during the Civil War, and we've been at the number 9 for roughly a century. And so if the Democrats believe that the Republicans have abused their power for their own political ends, then certainly Democrats would be well within their rights to enlarge the number of seats on the Supreme Court perhaps adding 2 or 3 seats so as to counter the abuse of power under Trump and McConnell. We won't hear very much of that during the campaign season, I expect, and certainly the presidential Democratic nominee, Joe Biden, has not spoken much about it. Other Democrats are more outspoken. I think that we'll wait and see who wins the November election. But there would certainly be every reason for the Democrats to assert power if they were to regain control of the Senate and begin to counter the political moves of the Senate Republicans over the last 4 years.
Betty is wondering, do you think some of the rush to approve a justice surrounds the pending case of Obamacare coming up soon?
Yes, that's an excellent, very insightful question. I think that what Senate Republicans are hoping is that this case involving the constitutionality of the Obamacare from a number of angles will allow the conservatives to place yet one more of their own on the Supreme Court who could rule on the constitutionality of Obamacare, the Affordable Health Care Act, and perhaps from their view strike it down. This would be deadly to Americans. Deadly is the right word, I believe, because remember, some 30 to 40 million Americans gained health insurance with the passage of Obamacare. And the Republicans have been railing against it ever since, threatening to overturn it, which they've not been able to do, even when they controlled the presidency in both houses of Congress. And as many Americans know, Donald Trump's administration is leading the way to asking the court to strike down Obamacare. And what Americans most need to know about this lawsuit, frankly, is that in the lawsuit, by asking the court to strike down Obamacare, they would be asking the court to strike down those provisions which protect Americans against denial for preconditions. That is, they are hoping to overturn the essence of Roe versus the essence of Obamacare, which in effect would mean that those 30 or 40 million people, or many millions, who have gained health insurance will lose it. And the many millions of people who now do not have to fear the loss of health care coverage because they have a pre-existing condition will in fact lose that coverage. And if you think about where we stand at this precise moment in American history, with millions of people suffering from COVID-19 during this horrific pandemic, if people who have contracted COVID-19 and are suffering the many long lingering effects of this dreaded disease are denied coverage for their pre-existing conditions, then in effect the Republicans will have denied to millions of Americans coverage for the impact of this dreaded disease, a dreaded disease which I can easily remind everyone did not have to reach this scope or its intensity if in fact President Trump had in January and February been truthful to the American public and said this disease is deadly. It's 5 or 6 times more lethal than the flu. It afflicts the old, but it afflicts the young, as he told Bob Woodward in the tapes for his new book, Rage. And while Donald Trump continues to try to downplay the lethality, the severity, the extent of the coronavirus, he cannot get away with it if we Americans insist on adherence to truth and facts, because remember, these words are Donald Trump's own words. And so I think that Betty's question is the right one to ask, because I think that conservatives are hoping that with yet another conservative member of the Supreme Court, that they will in fact be able to strike down Obamacare. The other area, quite frankly, is the effort by conservatives to strike down Roe versus Wade and remove reproductive freedom and reproductive rights for American women that they have enjoyed since 1973. President Trump has made no denial of his desire to overturn Roe versus Wade, and at least one of the prospective nominees to the Supreme Court is a pro-life person, and there is hope on the conservative side, perhaps the expectation, perhaps knowledge that this jurist, if in fact she becomes a member of the Supreme Court, I'm talking about Amy Barrett, that they would have a crucial vote to remove reproductive freedom from among the ranks of constitutional freedoms enjoyed by American women since 1973. And when President Trump talks about making America great again, is this what he has in mind? Turning back the clock so that American women lose their reproductive rights, forced to turn to back alley butchers, and suffering infections and even death. The landmark decision of Roe versus Wade brought some civilization to this country and was a critical decision to advance the cause of women's rights here, particularly in the area of reproductive freedom. It may be the case that Trump, McConnell, and Senate Republicans are taking dead aim at reproductive rights. And that's something that American women, no matter their party affiliation, Republican, Democratic, Independent, have to think about with the upcoming November 3rd election, that voting for President Trump, who has vowed to strike down Roe versus Wade, can be undercutting the very rights that they enjoy and depriving them of their personal autonomy over their own reproductive organs, leaving to some old white men the power to choose whether or not women can continue a pregnancy. There is no comparable power exercised by old white men over male reproductive organs. Why should it be so different in this country? We can ask fairly, why can men choose to govern their own reproductive organs but not women? This seems to me to be a gross violation of the principle of equal protection for all Americans. Great question.
Yeah, thank you. So Jeff wants to make it clear, is there anything constitutionally to stop the Republican Senate from filling the seat?
You know, so that's a very important question. Unfortunately, it's going to be very difficult because given the control of the Senate by the Republicans, Democrats would need 4 Republicans to peel away to refuse to go forward with a nomination. Susan Collins of Maine and Lisa Murkowski of Alaska, 2 Republican women in the Senate, have indicated they don't think that hearings should go forward, that a nomination should be made until after the election. That's 2 votes. Where will the other 2 votes come from? Utah Senator Mitt Romney announced just the other day that he will support President Trump's nomination, and that was deeply disappointing to many who held high hopes for Romney's principled behavior, because you recall he was the one Senate Republican who had voted to impeach Donald Trump this past summer. And I certainly admired him for his courage, for his principled stand, and had high hopes that he would continue to exhibit similar principles. It may be the case that Senator Romney has felt ostracized by his own conference, and then that's difficult to do. That's a difficult position to be in. Maybe he has decided that he didn't want to be ostracized anymore. Who knows? But it's deeply disappointing. It may be the case that another 1 or 2 Republican senators will come forward and announce that they won't support a nomination before the November 3 election, but that seems increasingly doubtful because President Trump has announced that he will declare who his nominee is this Saturday. So we are roughly 72 hours or so away from Donald Trump's announcement. So any Republican senators who want to take the high ground, who want to act with high principle, need to come forward very, very quickly.
Okay, let's do just a couple more questions because we're kind of running out of time. There's kind of a discussion going on in here about why Justice Ginsburg did not choose to resign under the Obama administration. Could you talk a little bit about that?
Sure, that's a nice question to address. A lot of people have wondered why Justice Ginsburg did not take the opportunity to retire from the bench after President Obama had won election and the Democrats controlled the Senate. The concern is that if Justice Ginsburg had decided to resign, that Obama and the Democrats in control of the Senate would have been able to push through with considerable ease a person who might have shared the views and values of Justice Ginsburg, thus perpetuating control of that seat in the hands of a progressive justice. So it's a fair question to ask. Justice Ginsburg probably was not interested in retiring at that point. She had just reached the apex of her career. She was now the senior member of the progressive wing, and certainly she harbored hopes that with the addition of one more progressive on the court, she would be writing majority opinions or would be deciding who writes the opinion, enjoying the status of seniority. I think there's another factor here that comes into play that probably helped to persuade Justice Ginsburg to stay on the court, and that is her good friend, Justice Sandra Day O'Connor, had just left the Supreme Court. Many are aware that Justice O'Connor left the court when her husband was diagnosed with Alzheimer's disease, and she wanted to spend what time she had with her husband. Certainly a noble concern and a noble move. But the fact is that Justice O'Connor's husband went downhill so quickly that there was barely any time for her to interact with him before the dementia overcame him. And she made clear to friends that her decision to resign from the court was a terrible mistake. She regretted it. She wished that she had stayed on the court. That decision by O'Connor, the regret, the strong feeling that she had made a mistake to leave the court, may have weighed heavily in the thinking of Justice Ginsburg in deciding that she would stay on the court. And then, too, she had every reason to believe in 2016 that the Democratic nominee, Hillary Clinton, would in fact win the presidency. She did. She won more than 3 million votes. She had 3 million more votes than Donald Trump. But of course, the system is not based on a popular vote, which I believe it should be, but on the antiquated electoral college scheme that no longer fits America. And she then was excited about the prospect of the first woman president replacing Justice Ginsburg, probably with another woman. So there are a number of reasons that probably helped to explain why she didn't make that decision. In the benefit of hindsight, of course, many people want to say that they wish that she had retired. But let's understand, here was a towering legal genius that not only spoke volumes for the views of progressives and a great champion of gender equality. Really, why should she have left the court when she was at the height of her powers?
Right. We have a lot of great questions coming in, but we're just about running out of time. So let's end on this last one from Troy. And he asks, Dr. Adler, what is RBG's most influential Supreme Court decision?
That is a really good question from Troy. I appreciate that. She has a number of them, but I think her decision in the 1996 Virginia Military Institute case is the most important case because in that opinion for the court, she wrote the opinion for the court, she was able to advance in a wholesale manner her most deeply felt, deeply held theories of gender equality in holding that the state of Virginia provided for its sons but did not provide for its daughters? And why should young women be denied the opportunity of attending the historic, prestigious VMI, and why should they be denied equal protection of the law? She prevailed in that case in a way that reflected success for her views and values and theories that helped to shape American law going back 25 years and more. And there's a heartfelt moment in the court's deliberation that I'd like to share with our audience. In that case, Justice O'Connor, who voted with the majority and had the seniority, was in the position to decide whether she would write the majority opinion or whether she would assign it to another member in the majority. And Justice O'Connor and Justice Ginsburg had become very close friends, sisters-in-law, as it said. And Justice O'Connor made a very nice gesture toward Justice Ginsburg when she said, "This is Ruth's case. This reflects Ruth's hard work. This is Ruth's hard-won victory." And she assigned the case to Justice Ginsburg. And so when Troy asked what is her most important decision, I think this probably is it. And if it's not, it's surely one of the most important opinions that Justice Ginsburg ever wrote. Thanks for that question.
Yeah, thank you. And thanks to everybody who submitted questions and comments. Thank you all for interacting with our video. And thanks for spending the last hour with us. We really appreciate it. So we're going to end the program there. Thank you so much.
Thank you. My pleasure. Great to be with all of you. Taylor, thank you so much. Great to work with you tonight. And we look forward to seeing you next week as we continue this weekly series of constitutional conversations presented to you by the Alturas Institute. Long live the Republic. Good night.
Good night, everybody. And please follow us on Facebook, Instagram, Twitter for more updates on upcoming events. And thank you to everybody who donated. Good night, everyone.